in federally funded educational programs. Now, you may also recall that FAIR previously filed public comments on two proposed Title IX rules, one which governs sex-based discrimination in educational programs in general, and the other governing sex-based discrimination in the context of sports. Now, the final rule, which came down last week, which is more than 1,500 pages, covers a wide range of topics which can be confusing and incredibly overwhelming to the layperson. I'm sure many of you, including myself, have a lot of questions about how this new rule will affect you, your children, especially your daughters. So in an effort to provide you with what we feel will be a valuable and very timely review of the final rule, call it the final rule, we've invited a panel of legal experts to discuss the issues raised by this rule that are of greatest concern to members of the FAIR community. So joining us tonight are Ilya Shapiro. He's a senior fellow and director of constitutional studies at the Manhattan Institute. Previously, he was executive director and senior lecturer at the Georgetown Center for the Constitution, and before that, a vice president of the Cato Institute. Ilya has testified many times before Congress and state legislatures, and he holds an AB from Princeton University, my alma mater, and an MSc from the London School of Economics and a JD from the University of Chicago Law School. Also joining us is Candace Jackson. Candace served as acting assistant secretary for civil rights and as deputy general counsel in the U.S. Department of Education from 2017 to 2021. And while there, she spearheaded drafting the Title IX regulations that we'll be discussing now that the Biden administration just amended with their new rule. As an attorney in private practice, Candace advocates for common sense application of civil rights laws in schools and workplaces. And finally, we have Michael Allen. Michael Tad Allen, I should say. Michael followed different paths in his legal career, making him really a unique advocate for student and faculty rights. He graduated from the University of Pennsylvania with a PhD in history and sociology, and he spent over a decade in academia as a professor of history. Michael's passion for civil rights and individual freedoms led to a decision to pursue a law degree, which he probably regrets now, and he graduated from Yale Law School in 2010. Michael began his legal career as a clerk for the Massachusetts Supreme Judicial Court before moving on to work for several reputable trial practice firms. There, he honed his litigation skills and gained an interest and experience in cases dealing with higher education. He founded his own firm in 2018 to focus on the cases he's passionate about, which is representing students and employees in disputes with colleges and universities. So he's obviously quite busy these days. So now that I've introduced everyone, I think let's just jump right into what I think is probably the big topic, the big question on everyone's mind, which is this Title IX rule and its impact on, like, what exactly is the impact? How broad is it? How does it affect sports? Or is that issue still awaiting determination? Is a Title IX proposed ruling on sports still pending? Or is it contemplated by the ruling we got last week? So Ilya, do you want to start us off with that?
Great. Thanks for having me. This is not my usual Zoom background. I happen to be at a distillery in Texas Hill Country where I'm at a retreat for a law firm, one of my side hustles, the Burke Law Group, which is a general practice boutique, including civil rights. So if you're looking for some good lawyers, we might be able to help you out. But regardless, happy to be here. And if you see me imbibing, it is happy hour after all, so I will be tasting some of these bourbons that are on tap here. All right, so let's just jump right in. So Title IX gets a lot of coverage, especially now. You know, it's 10 days ago, 11 days ago that the new regulations were put out, 1,500 pages of gloss on Title IX. You think, well, Title IX must be some big, complicated statute. Actually, it's 37 words. So it was enacted in 1972, and I can quote it in its entirety. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So that's it. That is the entirety of the federal law on which all of this debate, all of these regulations are hanging. And as Monica said, the part of the new rule that's getting the most attention is the expansion of Title IX to cover gender identity. I'm going to go through that in a moment, but it means that even as educational institutions may continue to separate facilities like bathrooms and locker rooms by sex. Quote, preventing someone from participating in school, including sex-separate activities consistent with their gender identity, is now illegal. So let's look at some specifics of what that means, because this is the expansion of sex-based discrimination and sexual harassment. Sexual harassment before these new regs means conduct on the basis of sex that satisfies one or more of three things: quid pro quo harassment, unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to an education program or activity, or sexual assault, which is further defined in various ways, including stalking, domestic violence, etc. Now, the sex discrimination and sex harassment have been expanded. So discrimination now includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. Curiously, though, gender identity is not defined. Now, there's a similar expansion of sex-based harassment. Again, sex-based harassment now includes sexual orientation and gender identity. But there's no definition of what that kind of harassment or discrimination based on gender identity means. So again, this is an expansion of definition of sex or sex-based to include these terms, and largely based, legally speaking, on the Supreme Court's ruling in Bostock versus Clayton County from a few years ago, from 2020, which said that the protections against sex-based discriminations in employment, that's a different federal law, Title VI, now apply to gender identity and sexual orientation. Now, I think that's a weak read, and this is why we're seeing a lot of lawsuits that Candace is going to be talking about, because the Bostock court itself, the majority there, said that we don't purport to address bathrooms, locker rooms, or anything else of the kind. And again, gender identity is nowhere defined. And I think, if anything, under Title IX, limiting it to binary sex-based definitions, as has always been the case, is even stronger than Title VII, because whether you're looking at kind of a textualist reading of sex, whether you're looking at legislative history, that Title IX was meant to expand opportunities specifically for biological women, or the purpose of the law, again, whichever methodological tool you might employ, it's really the Biden administration is going on off on a tangent, or going very far ahead of its skis, as far as I can determine, as a matter of law. And Candace is probably going to talk about that with the various lawsuits that have been filed. But Monica, you asked about sports. That can has been kicked down the road. So there was a notice of proposed rulemaking. This is the way that these regulations work administratively. The same year, I think that this one was noticed 3 years ago. I mean, it's kind of interesting that it took them 3 years to finalize the rule, because it started back in the very first year, the first few months of the Biden administration. It took them this long because I think they recognized it was controversial. And the sports-based one was noticed at the same time. But explicitly, the guidance given with respect to these new 1,500 pages of regulation is that it does not apply to sports. So if you're in a school district or state or locality that limits sports access by biological sex, nothing changes. Conversely, if you're in a district or state or locality where biological males are allowed to play on women's sports, then that rule can be enforced without the education department necessarily getting involved. So that rule is kicked down the road, presumably for a putative second Biden term, in which case they will likely, the thinking goes, mandate the access of biological males to women's sports teams. But for these other purposes that have gotten a lot of attention, bathrooms, locker rooms, etc., as if you are whatever gender identity you're announced, you have to be given access to those kinds of facilities. So potentially, a high school boy says, well, one day to the principal or the phys ed teacher, what have you, today I'm a girl, has to be allowed access to those facilities.
Just to be clear, Ilya, if a school does not specifically restrict sports to biological girls as opposed to just girls, does that make a difference? Does the word biological have to be sort of pronounced?
It's the Department of Education is taking no position at this point. So
not at all.
You'll have to litigate it. Otherwise, it's going to be litigated. It has been litigated, but this rule does not provide support to either side in that.
Okay. Now, do we know what if there were any rationales, maybe there weren't, or any reasons or evidence relied on by the education department? Can they just? It seems this ruling seems rather arbitrary. Was it based on anything that you know of?
Well, it's part of, I think, the theory of civil rights, of trans rights, of gender identity and sexual orientation by the decision makers in this administration. Now, they took something like 250,000 comments, which is a lot. That's not the usual case for administrative procedures. And so they had advocates certainly on both sides of the question. But you put your finger on probably the central issue, at least with respect to the rule itself. Michael will get to the due process aspects, and then that bleeds into the free speech aspects as well. But courts will be looking at whether that redefinition is indeed arbitrary and capricious in the legal term of art, or whether there is some substantive basis to reinterpret those 37 words that I quoted of Title IX to cover that new expansive definition.
Okay. All right. Thank you, Ilya. Now, I don't know if you want to jump into this immediately, Candace. We can wait, but I think this might be a good time for you to weigh in. Is the rule, and I think Ilya touched on this, is the rule subject to legal challenges? And if so, what are these challenges, and have they already started?
Yes. That was a really great overview to help us understand why the rule is already being attacked in courts, and what issues are being raised in those legal challenges, and what might happen with them. So far, I'm counting 3 different lawsuits that have been filed challenging the rule. One of them is filed just by Texas. That's obviously filed in Texas. Another is filed on behalf of four different states, and it's filed in Louisiana. And then a third is filed by 4 different states and a couple of advocacy groups, including Independent Women's Network and a group called Speech First. And that third lawsuit is filed in Alabama. So the Texas lawsuit and the Louisiana ones are both in the 5th Circuit Court of Appeals, the Alabama one in the 11th Circuit Court of Appeals. All of them are challenging the new Title IX rule under the APA, the Administrative Procedures Act, and covering all the basis grounds that you can challenge an agency's regulation under that law. The APA stands for the idea that if an agency is going to interpret statutes and start issuing binding rules and regulations, that agency needs to have public notice of the new rule, accept public comment on the new rule, and in the end, their final regulation has to be reasonable, and it has to be based on reasoned grounds, including having considered all the evidence, pro and con, benefits and costs that's been presented to the agency. So there are several ways to have a rule invalidated under the APA, claiming that it is in excess of the statutory jurisdiction or authority. In this case, Title IX was a statute that Congress passed back in 1972. And so the Department of Education only has authority to issue rules and regulations and enforcement actions under Title IX because of the statute, the 37-word statute that Ilya pointed out, that Congress originally passed. So, just as a even wilder example than what they're doing now, if the Department of Education all of a sudden said that Title IX, this 37-word statute about sex discrimination, is now going to be used to, regulate what schools do with guns, that would be so wildly separate from the statute that Congress passed that it would be outside the Department of Education's authority. And all 3 of these lawsuits are raising that argument, saying that gender identity and sexual orientation go well beyond any kind of statutory authority that the Title IX law actually gives the department. You can also argue that and these lawsuits do, that an agency's action is simply arbitrary and capricious. That's another ground to strike down the rule. And arbitrary and capricious seem like pretty good fits in this kind of situation, where the department just kind of shrugs and says, you know, we're introducing these broad sweeping concepts that are new to society, have never been used in society, you know, before the last 10 years or so, maybe. We're not going to bother to define them. We actually don't need to define them. They're so well understood. They're used everywhere these days. So no need to define our terms. That can be considered arbitrary. Not paying attention or bothering to respond in a substantive way to the objections raised by the over 200,000 commenters who weighed in on this rule. That can be a reason to find the rule arbitrary or capricious. That it's basically a legal way of saying the department set out with its end goal in mind and was determined to issue a rule for its own politicized reasons. And any kind of evidence, any kind of reasoned argument, any kind of objections were always going to be, in a predetermined way, swept aside in favor of the political result that the department wanted. There's also a spending clause argument here. The Title IX, unlike Title VII, which the Bostock case was decided under, Title IX is a spending clause statute, meaning the only way that Congress even grabbed up the authority to regulate schools in this way on this federal civil rights issue was purse strings, and saying, well, you don't have to do this, states, public schools. You don't have to do what we're saying, but you have to do it if you want our federal money. So it's a spending clause statute to begin with. And there are rules around how far Congress can go, or the department in interpreting Congress's action can go in being fair to schools and states exercising its spending clause power. You can't do something that's so coercive that it really offers states no viable alternative except to feel compelled and coerced into taking an action. You're not supposed to do something that is imposing a condition on the states and schools that's so ambiguous that it leaves schools constantly in doubt as to even how to comply and stay out of trouble under Title IX. And you can't pass a rule under a statute like Title IX that in and of itself starts requiring schools and states to violate the Constitution. All of those grounds are raised in these three lawsuits and seem pretty appropriate. Monica, if you have just a couple minutes, I just wanted to point out a couple of specific things that are highlighted in the individual lawsuits. I think did put in the chat copies of the actual legal complaints. They are not full of legalese. They are easy reads. They are informative. They are pull no punches. And it is good to see this kind of appropriate advocacy.
And they're serious lawyers. They're serious lawyers. These are not gadflies.
That's right.
So these are going to be serious challenges.
Absolutely.
And to remind our audience, how many lawsuits, how many different states total?
Yep. So right now I've counted up 3 different lawsuits, but in total representing 9 different states, plus a couple of nonprofit advocacy groups.
And do you expect, have you heard in the grapevine, through the grapevine, do you expect more cases? I mean, I would imagine at least half the country, states, would be tackling this issue.
I think maybe a handful more states themselves, but I also think that other advocacy groups are going to jump into this. I think that spreading the love across the country in terms of anticipating further appellate circuit divides on this issue only will help to increase the odds that at some point relatively soon, the Supreme Court is going to have to revisit its unfortunate Bostock decision. and clarify for us that at most that decision not only addressed itself to workplaces and schools are very different, but also only dealt with situations where sex itself doesn't matter. And so this idea that, well, transgender status and homosexual status are characteristics that inherently involve taking into account a person's sex, that argument only works logically within a civil rights framework if you realize that that's only talking about saying, here are areas where sex doesn't matter, therefore sexual orientation doesn't matter, therefore transgender status doesn't matter. If you're saying don't fire somebody, and that's what Bostock says, don't fire somebody because they're male or because they're a man or because they're a woman, then also don't fire them because they think they're a man or a woman. That's kind of what Bostock says. Bostock does not say where sex does matter, gender identity also matters. That's not what Bostock says. So it's a big misunderstanding of lower courts, and that the lower courts that have in the last few years applied Bostock in this runaway train kind of way in the direction toward adopting gender ideology, that has given the Department of Education here its hook, and that's what the department leans on. They just string cite a bunch of lower court appellate cases saying gender identity is part of Title IX now. Gender identity is part of Title IX now. I don't think that should survive scrutiny under the Administrative Procedure Act and the legal attacks that are here. I don't think that's enough, but that is what they're able to point to at this point.
Yeah, Mike, I'm going to get to you in just a second, but I have a follow-up question for Ilya, just a very brief question. This is an election year, and nothing happens by happenstance or coincidence in an election year. Do you think that played at all into the decision of the Department of Education to kick the can on sports in Title IX?
Absolutely. And you're not the first person to ask that or some variation of that question of me today. Reporters are very curious about this. First of all, the release of this rule is not to get votes. As people learn more about it, it's unpopular. It's sort of part of their ideological policy commitments is why the administration is doing it. But at a certain point, they realize it will be controversial. And so that's why it's taken 3 years. But at a certain point, the key decision maker said, okay, we got to go now because it's still 6 months before the election. Every time we wait, that's going to hurt us. So it was released, in April rather than July, say, because of that election pressure. And absolutely, the sports rule was held because, again, the key senior decision makers, political advisors said, okay, that's going to be a bridge too far. We got to save that for a second term.
Why didn't they save all of it for a second term? That's what I don't understand.
At a certain point, you use your political capital for something, and they decided was important enough.
I think as just to add to that, as evidence, I think of what Ilya's pointing out is when you read through, if you put yourself through it, if you read through the 1,500 pages of what we call preamble, that the explanatory, the department's explanation of its actual textual regulations, those 1,500 pages read like you are watching paint dry. It is as it is as uninteresting and vanilla as any kind of bureaucratic write-up could be. And that's a deliberate strategy. I firmly believe that, because having been on the inside of writing Title IX regulations, I recall very specifically, we chose that strategy for our proposed rule so that it would sound very boring, very neutral, very uncontroversial. And then we went into a lot more detail and flavor and color and passion, I would say, in defending the final rule. They chose the opposite route. They don't want this highlighted in politically. They know it's a loser the more people find out about what it really does. But they do want, I think, like Ilya said, they do want to pay back their they've been promising this. They've been promising this to the so-called LGBTQ support side of things for a long time.
Okay, thank you. All right, Mike. So this is a big issue. I think it covers more than Title IX, actually. But what happens now with these new rules, what happens to students who have sincerely held beliefs, most likely religious, that keep them from, respecting the gender identity of someone, a teammate in the context of Title IX, let's just say?
About that, it could be that Candace and Ilya are better positioned to answer that one, because I think we don't know. There are spectacular examples of, say, Leah Thomas participating on women's sports teams, things like that, and we know that that's controversial even among teammates. But that, even under the old regulations and the old law, to my knowledge, that didn't really produce any legal action necessarily, or certainly no binding decisions. And so I'm not sure. I think it ties into the sort of repression of free exchange of ideas on campus, in the extent that I think trans ideology is very popular on campus, very unpopular off campus. I think that's why these regulations were delayed. But I think on campus, there's a great deal of fear to confront that issue and stand up. I mean, I don't think it's any accident that athletes have come forward after they graduated to speak out as activists against this, and not during the time they were teammates. I will say so just so your audience knows, at Allen Harris, we represent primarily students and faculty against colleges, everything from representations of our clients in administrative proceedings at the college or university level, and all the way up to full-blown lawsuits and appeal, if that's necessary. We get very few inquiries about the trans issue, and when we do, it's usually connected to free speech. Professors who have for whatever reason, they refuse to use pronouns, or just sometimes they're practically happy to use pronouns, or I think this is where many people are, is they're happy to exercise personal courtesy, but they're not happy to be accused of things they don't even know or can tell when someone appears to be one gender, but they proclaim to identify with another, and then scurry off to the administrative offices of the college to file a complaint if they've been misgendered, or sometimes perceiving that someone else was misgendered, which I'll get to in a second. In other words, I think the regulations as they're written now, if I could maybe push this a little sideways, really encourage young people to become volunteer Stasi agents, Stasi being the Staatssicherheit of the East German Democratic Republic, immortalized in films like The Life of Others or something like that, which was scurrying around East Germany, basically asking people to inform on their neighbors. Everyone is asked to be their brother and sister's keeper under these regulations and others. But I think the vast majority of complaints under Title IX on campus are going to continue to be by biological men and women who identify as men and women, who are engaged in sexual relationships with others, usually in heterosexual relationships, and for whatever reason are coming forward to complain that someone has assaulted them, created a toxic environment for them, and whatnot.
Mike, before you go
sorry,
further
go
on the due process issues with reporting assaults and what have you, to put one more beat on your point on the chilling of speech, as Candace and I were talking about, the nebulous or the non-definition, you have this expansive new coverage for gender identity, sexual orientation, but nobody knows what it is. And so the combined with some of the due process stuff that I think you're going to talk about in terms of who can investigate and whatnot, the Title IX coordinator or the DEI official or what have you is now going to be able to investigate, allegations of some politically incorrect speech, someone misheard something, someone's feelings were hurt. And that dynamic, as students and faculty realize that this is what's going on, that will make them hold their tongue. And you're not going to get reports. Allen Harris does not represent people who says, well, my speech is, well, sometimes, but you don't get a complaint saying that it's just kind of this campus culture of you can't discuss certain issues lest you get thrown into this investigative mechanism.
And it takes, you could set such a lawsuit up, but it takes someone of extraordinary courage to say, now I'm going to say the things that are most unpopular and make myself a target and alienate myself from all all these people, we have an enormous number of clients who are well-meaning, often, we represent professors on campus, so they're often identify with the left, let's say. And then they wake up one morning and they've said something that they didn't even anticipate was politically incorrect or whatever it might be. We have one client who had the temerity to suggest that the entire tradition of Western classical music was probably not systemically racist. And he said this in July of 2020 and was immediately dogpiled by all his colleagues who he thought were his friends, right? And trusted them. And that's a very typical pattern we see. And for students, it's no different. For students, it is absolutely no different. They find themselves, I had clients where it's no different from the complainants, incidentally. It has absolutely brought down entire sports teams where allegations are made, say on the track team of one school where we represented someone, and eventually led to the coach resigning and the basically, not this far, but it basically as if the varsity season in these individuals' senior year had been canceled, basically. Sorry, Candace, did you want to ask a question?
Just to back that up, I mean, look what happens when, middle school girl athletes out in West Virginia stand up to the idea that males can be allowed to compete with them. And they're the ones that get punished. The girls are the ones that get punished. So asking students to be the ones to set themselves up for these test cases, it costs them a lot.
Right. And they don't have any, not moral capital. They don't have any capital. Their parents are paying for their education. They don't have the wherewithal to stand up in a full-blown lawsuit. I mean, I think that's why institutions like FAIR are so important, because they can afford to invest in suits where there are no monetary damages, but the issues at stake are of tremendous importance for the culture of, be it on campus or in local PTA meetings or just in our civil society, because they come at it from a civil rights perspective, not an individual self-identification of whatever identity you might find to be subjectively appealing at the time. I just find that tremendously important. So I guess I'm giving a pitch for you, Monica. Should I get into the
You should get into the slides and the due process issue changes.
So again, I think the vast majority of these rule changes for due process rights on campus are not going to affect, not going to affect transgender issues, only because those are a small minority of the issues that come forward on campus. The vast majority of these issues are going to impact what I think we would have thought of until recently as conventional sex on campus between men and women, usually people who wanted relationships with each other and something went wrong. And I would say in our experience, just based on a sampling of our client base, I think we see a broad bell curve. At the far end of the tail are completely false allegations that are maliciously made by an accuser accusing an individual of rape or something of that. Very rarely do people just make things up. Most people are very bad liars. In the broad middle are accusations where people will reinterpret a very difficult breakup, relationships that went wrong, and they've been taught to believe on campus that if they subjectively believe something made them feel uncomfortable, then it is indeed something that has created a hostile environment, and so forth. I want to really take some time to emphasize how these rules have changed to accentuate subjective beliefs on campus, to really open the door to what I would call let no subjective feelings be left behind sort of policy in American education. On the far other end of the tail is true criminal behavior. And I don't think we should lose sight of the fact that there are actual real sexual assaults that happen on campus. And I know a lot of people who represent both women and men on campus. No one in this area, no one who practices in this area is happy about the existence of real sexual assault. The problem is, by defining so many things as sexual violence, including what they call verbal action, as sexual assault or violence, even our dunderheaded administrators on campus are losing the ability to discern what constitutes real violence, because when it happens, it is real, it is harmful, and it has lifelong consequences. And I find it personally, as well as legally, wrong and offensive that those categories can be conflated in the way they are now, especially on campus. But before I go into actually the procedure, I want to talk about what the major concern, at least in my mind, and at least as it was presented to us as the rules were changing, of the Office for Civil Rights was well, at least what they said. I think Ilya and Candace are correct that they were basically pandering to party radicals, but that's harder to prove than to point to what they were actually saying. What they were actually saying is we're concerned that there's suppressed reporting of sexual assault on campus. No one who does this really believes that there aren't incidents of sexual assault that are not reported. I think there are many reasons why a victim of sexual assault would not come forward and report, not least of which that they're intimately involved sometimes with their abusers and things of that nature. And that's a serious issue. I think the idea that there is somehow a unique climate on campus that has led to hundreds of thousands of rapes not being reported on campus is absolutely deranged and preposterous, though. And I just did a little, an idle statistical breakdown. You can find any number of references to 1 in 5, 1 in 4 women, sometimes higher. There was a lawsuit filed by against the last set of regulations by the ACLU, which, if you did the math, indicated that they might honestly believe that there was a 210% sexual assault rate on campus. But this would mean that, the major flagship university in the state of Connecticut, where I live, is the University of Connecticut, of basketball fame, which has about 10,000 students. That would mean a violent crime rate at UConn, which is a very leafy, rural area campus, very picturesque, as you would expect. I've actually been on campus where there are deer wandering around the campus, things like that. You would have to believe that there were, the violent crime rate was in excess of 10,000. And by comparison, Bridgeport, one of the biggest cities in Connecticut, which has twice the crime rate on average, has a crime rate of 42.6. In other words, crimes per 100,000. Just to give you a comparison, right? You'd have to believe that the crime rate in a leafy campus such as Storrs or any number of campuses across the United States is something like 200 times that of a very crime-afflicted city such as Bridgeport or whatnot. So I'll just skip through that down to what the process is going to actually look like on campus. So I don't know where this moral panic is coming from, but that is simply the moral calculation they seem to be using. So what process are they going to use to address this? There are a couple of major changes that I'm sure Candace is well aware of, especially, and Ilya no doubt too. It had gotten so bad on campus, and you could look at one of the the benchmark decisions out of the District of Massachusetts, the Brandeis decision back in, I think, 2013, by Justice Saylor, or Judge Saylor, pointed this out. It was getting so crazy on campus, and it hasn't stopped being crazy, that completely preposterous rulings on campus were coming down. And so one thing that Betsy DeVos in the former Office for Civil Rights wanted to do was introduce fair process, which is no different from the process that is available to people outside of the realm of education. In other words, if you're an employee, if you're a working class girl and you accuse someone of sexual assault in the workplace, you'd fall under Title VII. That would be a classic, like a quid pro quo sexual harassment claim. Let's say you were in the workplace and you had Harvey Weinstein, someone like that, as your boss. You would fall under the federal statute of Title VII. You would be subject to cross-examination. You would be subject to, your accused would be entitled to due process if they were going to be found liable, or your employer was going to be found liable. So what Title IX has done over the course of the past 20 years now, really, is set up a system of procedures on campus that apply only to college-educated American citizens and nowhere else in American society, including special rules for consent and also special rules for process, which unfortunately the current administration, and I say this as a lifelong Democrat, are curtailing due process rights for the accused on campus because somehow that's become a progressive policy. There's an expansion of who can file a complaint. This ties into what I said earlier about the sort of encouragement of volunteer Stasi agents on campus. It's not just the complainant, in other words, the alleged victim who can file a complaint, or say the school itself. I think we all recognize that an authority might want to bring a complaint on its own accord if it finds out that there's bad acting going on campus. But now it's any student or employee. In other words, if you heard of someone somewhere, sometime that might have had something happen to them, you can bring a complaint too. If you're a former student, if you're a former faculty member, you can bring a complaint. And we've even had many cases in which, modern society being what it is, a student is interacting with someone who's simply in town, a stranger or a student at another campus, not completely unrelated to campus activities at their own home campus, and that person can submit a complaint. There's a willingness to entertain complaints wherever they may come from. And of course, if you believe that the violent crime rate on your campus is 200 times what it might be in the rest of society at large, then of course you must think that, somehow, some way these things are being suppressed on campus, and you're trying anything you can do to find these complaints wherever they may come from. That's one of the consequences. Skip down a little bit to some of the concrete changes. I just covered that. I'll skip over that. Jurisdiction has been wildly expanded. And, it used to be in American life when an industry was told by the American government that they didn't have to be regulated in some sphere, they would click their heels with joy and move on and say, okay, we don't have to do that. Well, under the previous regulations, universities were relieved of the obligation to enforce regulations subject to Title IX outside their programs or activities, and especially outside the United States. And this is important because colleges and universities routinely have students who go abroad. They might be participating in a program in Seville, in Rome, in Berlin, God knows where. And that's kind of part of the American educational experience, that you might spend some time abroad.
Buenos Aires for me, it was great.
Buenos Aires. My daughter, for instance, participated in a program abroad. It was a great experience for her. Many times the universities have only the, tangential control. They're contracting with foreign universities and things like that to provide these experiences. But now, universities clamored that this was a great injustice, that they wanted to exercise extraterritorial jurisdiction so their bureaucrats and Title IX officers could do things if they got a complaint that came in about an overseas program. Now the Biden administration and these new rules have said, yes, you have an obligation to enforce these regulations on programs and activities outside the United States. So that's one change. I won't go over the informal resolution rules. Thankfully, and I will say the regulations were not as bad as I expected. They did they preserved the what's called an informal resolution. That's sort of a mediated solution between the students. That is still preserved, except the Title IX coordinator can step in, and they have enhanced rules under the regs to approve or disapprove that and insert themselves into the process. In many cases, we're talking about things that probably would and should be governed in purely private life, or would have been in other generations. And I'm being quite honest about this. We're not talking about actual actionable criminal sexual assaults. We're talking about bad breakups, resentments stemming from intimate relationships. The standard of proof issue, there's a renewed emphasis that we should have the lowest standard of evidence, the preponderance of the evidence. To me, this is a red herring in point of fact. I've always thought the standard of proof issue was a red herring. The reason is because on campus, there's been a tendency since at least 2011 to ignore the evidence. So they're not even weighing the evidence. They're just simply disregarding exculpatory evidence whenever they get it, enhancing or even making up their own evidence based on imaginary things that they think might happen. Maybe you think I'm making this up. I just want to point to the Second Circuit case, Bengalatore, a very talented professor at Cornell University, who was accused of having an affair with a student in his laboratory, who, if I remember the facts correctly, just so happened to not be succeeding and was told, she needed to move on. This is an unfortunate part of many doctoral programs, as some students don't perform. And just turns out there was no evidence of this secret year-long relationship. And the Title IX office decided that the fact that there was no evidence was actually evidence that the relationship existed. And Justice Kearse in the Second Circuit had to remind them that the lack of evidence that a relationship existed actually did not support the proposition that it existed. This is the cloud cuckoo land of Title IX offices and kangaroo courts on campus.
Mike,
so if you,
Mike,
sorry,
Judge Kearse actually is, just to make this clear, is fairly on the left. I mean, she was considered for the Supreme Court by Jimmy Carter had he gotten an appointment. Not someone who's thought of as being, carrying water for the right or anything like that. But I've seen your slide deck, and I'm wondering, is there an increase in courts overturning these actual courts turning over these kangaroo courts or Kafkaesque inquisitions and things like this? Because, as to reiterate what all of us have said during this whole thing, the gender identity piece of these new regs is getting all the attention with bathrooms and sports and whatever else. But the due process stuff is really where the rubber hits the road in terms of the number of incidents and
this
things
will
that
be
hit the
this will
courts.
be 95% of the Title IX cases on campus or more will be conventional heterosexual relationships gone wrong. But to your point, actually, no. In fact, for the past 4 years, I've got a slide up here. Maybe your audience would be interested. Incidentally, everyone, this is a slide deck for a much larger presentation that I'm going to present to the Connecticut Bar Association. But this graph shows lawsuits filed by accused students annually, not all of which succeeded, but many of them have, much more so, incidentally, than the victim side suits, where the standards are slightly different that we don't need to get into. And they're less common, incidentally. They really spiked. They went up exponentially during the, prior to 2016. With the introduction of the new regulations, they've really tailed off. And I think one of the reasons why suits have been less successful, including, incidentally, we just did a trial in Houston against a school in the Texas state system and lost. But they were required, they didn't follow the rules. They were required to follow the rules. But even when the rules are set and they don't follow them, there's a limit to how baldly they can disregard the due process rights of students. And I think that's led to a lot of successful defenses of accused students from bogus allegations on campus. Those never lead to lawsuits, obviously. And also the lawsuits that we do bring, the way in which the campuses violate the civil rights of their students are much less overt. So it's led to actually a decrease in successful lawsuits, which is what you would want when the regulations are, I wouldn't say working perfectly, but when they're more effective. I would expect that this is now going, once these regulations take place and the universities do what they've been lobbying for the last 8 years, they revert to what they were doing before anyway, ignoring exculpatory evidence, denying evidence to students, denying them the right to cross-examine, and so forth. You're going to see this go up again.
Wow.
But I don't, check in 3-4 years and we'll see if I'm right about that. So I already said, I think standard of proof, very much a red herring. One thing that's not a red herring, obviously, is the return of the single investigator. A single investigator is where a school, and I understand why they do this. If you're a small school, maybe a liberal arts college with maybe 1,200 students, like the school I went to when I was a 20-year-old, you can understand why they don't have the resources to convene a massive quasi-judicial system on campus. That's expensive. It is. So they want to have a single investigator, someone they empower, usually the Title IX coordinator, to be the inspector, the prosecutor, the judge and jury, and also often appellate officer too of a case. That's the single investigator model, right? That you'll be the single investigator that soup to nuts evaluates the evidence and issues the sanction. The reason this is dangerous, and even victim side organizations like NCERM, Brett Sokolow's organization, has said this is maybe not the best model for fair decision making on campus, is that, and this is recognized, for instance, in claims adjustment in the insurance industry. If you're the investigator, you form an opinion of the case, you have positive bias selection, we all do, you get invested in your own preconceived notion of the case, and you prejudge the case. It's not that it's uninformed by the evidence. To some extent, if you're a good investigator, it may be. But there should be an unbiased, independent decision maker who then has the evidence presented to them and in a dispassionate way decides the case. Just like in an insurance scenario, they usually separate the task of claims adjusting from, who decides who gets paid what. So that they can have an accurate view of the situation. We'll be going back to the single investigator model. Unfortunately, I haven't seen, we don't know, the current regulations don't take effect until August of this year, but I suspect there'll be a massive move in the academic sector to reintroduce the single investigator. That would be, instead of having someone who investigates, brings the evidence to either a panel or at least an independent decision maker who hasn't been involved yet, and then makes a dispassionate decision under the previous regulations, subject to live cross-examination and real-time hearing with the parties. The other thing, I think I'll stop here. Sorry, Monica, did you want to interrupt me?
Oh, no, I just want to let you know we're almost out of time.
Oh, this is the last thing I want to talk about. Access to the evidence. Former rules where both parties get access to all evidence considered relevant or irrelevant. Any evidence selected, gathered, would be presented to the parties. Because if you have a biased, in fact, in many cases, the schools are arguing that they're just biased against the accused. They're not biased on the basis of sex. They're just biased against the accused, and they're allowed to do that. They've argued that in many courts in the United States. Well, at least you are allowed to have all the evidence. Now they must only provide a, quote, equal opportunity to access either the relevant evidence or the same written investigative report that, quote, accurately summarizes the evidence. In other words, they have to rely on the summary that the independent single investigator decided was relevant to their often results-driven decision-making process. And they don't have to give you all the evidence. You do have the right to ask for it, but we can only imagine what evidence is going to be considered, quote, relevant and irrelevant and excluded from the process. There have been too many court cases where they exclude relevant evidence that is exculpatory, and that they are the ones running around saying it's okay to be biased against the accused as long as you're not biased against them because they're men. So I think this is a really dangerous precedent, and we're going to see an increase in withholding of evidence from the accused in particular. But I also, just to say one last thing, I know we're out of time. I don't really understand why alleged victims want this process. The last thing they've gotten rid of course, is cross-examination, which I think everyone is probably familiar with, doesn't need to be dwelt upon. These kinds of procedural safeguards protect the person telling the truth. If you bring a real accusation against someone, you want to be able to cross-examine the accused because they are lying. You certainly want that right. And I have represented people who want that right because they are the victims. If you are the accused and accusations are being made against you. Of course, you want all the evidence and you want to be able to cross-examine your accuser, because that always favors the person who's trying to get at the truth. So that's the last thing I'll say, and I'll turn it over. Sorry for taking so much time.
Oh, no worries, no worries. Listen, I know I just wanted to squeeze one last question in for Candace, because I'm sure it's on everyone's mind. Candace, are there any arguments or reasons that this rule might be delayed, given that children are so affected? Is there anything schools or or parents can even do to forestall this?
So the lawsuits that have been filed, each and every one of them is asking the court to make a fast decision to delay the effective date. The rule is so far effective as of August 1st. But these lawsuits are asking for a delay in that date, in addition to enjoining all or parts of the rule on a temporary and then ultimately permanent basis. As far as what parents can do, I think that there's not necessarily a straight line between, if parents do this, then, a legal effect will be to, forestall the rule. However, I think it's absolutely worthwhile to get a jump on even knowing what to expect in terms of, will my particular school district be embracing or trying to avoid the worst of this rule? And to do that, you got to ask the questions. You have to think about how this can play out, whether it's your own child who you're concerned with showing up at school and asking for weird pronouns and that being respected and you never finding out about it, or whether you're concerned with your students being now in locker rooms with opposite sex students, or whether you're concerned with, your student being under threat of being called a sex-based harasser for not using weird neo-pronouns for their classmates or even their teacher. So whatever the scenario is that comes to your mind as being of concern as a parent, get involved, ask those questions directly of your school board, of teachers and administrators
Go
and
to
principals.
those meetings, ask for a
That's
meeting
right.
with your principal and see how they're going to implement this. What is the plan? Because they're all on notice. They know something's coming down the pike ahead of the next school year, August 1st. Now, one of these lawsuits might postpone that, who knows? But those are the officials that are in charge of implementing it, and there are going to be different ways of implementing it. But the rules as stated, again, the sports piece is punted, as we say, to use the appropriate metaphor for sports. But everything else, whether you're concerned about bathrooms or locker rooms, if your school accepts federal funding, there was a question about religious schools or private schools. If your school, whether K-12 or college or what have you, accepts federal funding, then it's subject to this rule, unless a court delays it as of August 1st.
Schools need to hear from parents that parents get it. Parents know that if you are going to lean in to trying to comply fully with this new rule, you are, as a school, committing sex discrimination and harm against girls and women at your school. The schools need to hear from parents that is the bind that this rule is putting schools in.
Just to give a pitch for what's going on with due process, there are jurisdictions, the Sixth Circuit, in the state law of Connecticut, there's been a strong decision indicating that cross-examination is an important part of due process. There are jurisdictions where there are greater safeguards for due process established by the courts, especially some of the circuit courts, than there are in the regulations. That's one thing that I find very curious about the regulations. I think there was a great deal of effort under the 2020 regulations to make them consistent with existing Supreme Court and appellate court law across the United States, and to set, in other words, let the most procedural protections be the floor. These regulations have tried to abandon that approach and go for a more dismantle due process protections, even if some jurisdictions have mandated it as the law of their states or jurisdictions under the circuit courts. So look for those circuits like the 6, or say states like Connecticut, where there's a ton of colleges. Some of them have reverted to being Montessori schools for adults, but nevertheless, they are subject to greater restrictions. We'll see how it plays out.
I'm curious, based on all these due process changes that seem just cuckoo for me, like Candace, you must have worked on some of this stuff under Secretary DeVos. How does it make you feel? Right. How does it make you feel? Forget, again, setting aside the bathroom gender identity, which gets all the headlines.
Yeah.
But this bread and butter due process stuff that covers, you know, all the stuff that Mike's been talking about, that you know, most students that are involved in, how does it make you feel that they're like taking all these standards and having an investigator be the investigator, judge, jury, and executioner, and all of that?
That's like, it's like
it really does feel like it's politically motivated. For some reason throughout the Obama administration, it was decided that it was kind of swept up in a wave of basically believe accusers. You know, the accusation is the evidence, is the verdict. I can't help but pull this back into the horrendous gender identity context. And that is to say, it is hard to imagine how even the most robust due process procedural protections are going to help very much when the accusation is you have now violated Title IX by refusing to use wrong sex pronouns, for example. Because the whole point is you have a right to do that under the First
Amendment. The
standard
is it's more than de minimis harm if they just hear something resound in the heavens.
Exactly. So the you know, having the opportunity for evidence and cross-examination and so forth isn't the point when it comes down to the very accusation itself is that you have done something that you have every legal right to be doing.
Yes.
Yeah, it falls under the rubric of compulsory speech at that point, doesn't it?
Absolutely. You either have to keep your mouth shut or that's right. Yeah.
Cool. All right. Well, thank you. Thank you all for being here tonight. And special thanks to our panelists. We hope this session was helpful and informative for you. And we are obviously so grateful for your support, but we also be grateful for your financial support. You knew this is coming, didn't you? If you appreciate the work that FAIR is doing and webinars like these and the other content we provide, please consider making a donation. We have a dedicated team. We're small, but we're fierce, and we work hard to keep you informed and empowered with information. And we rely on your support to do it. So you can find a link to our donation page in the chat. Again, thank you again all for joining us this evening, and we look forward to seeing you at the next event. Take care. Have a great night.
Thanks. Good to see you both, Ilya and Candace, as well.